Hello students. Are you ready for the dictation? Start. 16. To rebut the argument made on behalf of the petitioners with respect to their illegal detention from 4th January 2024, Learned Counsel for the respondents has referred to page 12 of the petition of Dilbag Singh to highlight that as per the case of the petitioners, they were detained in custody since 4th January 2024. It is argued that the said averments have been specifically replied in para 29b of the first reply dated 22nd January 2024 filed in the case of Dilbag Singh, in which it has been stated that no person was detained during the search proceedings and all the persons were given proper rest and food during the course of the said proceedings. Para 35 of the said reply has also been highlighted to show that in response to the averments made in ground C in petition, it has been submitted that there were no restrictions imposed upon the petitioners until their arrest on 8th January 2024 and the petitioners and other persons were free to loiter within their own premises during the duration of search as per general practice, and the same cannot be termed as detention, and that Section 17 of PMLA, which deals with search and seizure mandates certain requirements which were duly complied with. Para change. 17. Learned Counsel for the respondents has further referred to the additional reply dated 29th January 2024 to show that it has been averred therein that by virtue of Rule 3 Sub-Rules 7 and 8 of the Prevention of Money Laundering and the manner of forwarding the reasons and material to the adjudicating authority, impounding and custody of records, and the period of retention Rules 2005. The petitioners and other persons who were present at the premises were in possession and control of the locker, safe, almirah, documents etc., and thus, it was important to secure their presence within the premises in order to have access to, inspect and examine their contents and to avoid any sort of tampering with the potential proceeds of crime, and also that they were allowed to follow their daily routine and were not detained or compulsorily retained in the premises. It has further been averred that the petitioners were there within the premises on their own will and themselves offered to be in the premises during the course of the search. He further submitted that the plea on the aspect of grounds of arrest, which has been raised by the petitioners, is in ground 3 and the averment in the said ground is only to the effect that in the grounds of arrest, the arresting officer had stated that the petitioners did not cooperate with the investigation and had given vague and evasive replies on account of which the petitioners have been arrested. It is submitted that the said reason is not the sole reason for arresting the petitioners, and the reasons for arresting the petitioners are clearly coming from the grounds of arrest which have been annexed along with the petition, and in the said grounds of arrest, the details of the FIR which are pertaining to the scheduled offences had been mentioned, and the background of the case had been given, and every such aspect has been mentioned which in accordance with law was required to be mentioned. In the grounds of arrest, it is stated that in paragraph 13, it has also been stated by the Assistant Director that on the basis of the material placed on record, he had reason to believe that the petitioners in both the cases are guilty of the offence of money laundering as defined under Section 3 and punishable under Section 4 of the PMLA. It is argued that the petitioners have not laid any specific challenge to the said grounds of arrest, and have not even averred that the said grounds of arrest are insufficient, or that by reading the grounds of arrest, the offence is not made out. It is argued that since the petitioners had filed the petitions, the onus to show that the contents of the grounds of arrest were incorrect, and that the petitioners were not linked to the facts and circumstances which had been mentioned in the grounds of arrest, was on the petitioners, which they have failed to discharge. It is thus submitted that the said ground of challenge is also absolutely misplaced and deserves to be rejected. Para change. 18. Learned Senior Counsel has further referred to the Panchnama in both the cases to further argue that even a perusal of the said two Panchnamas would clearly show that no such direction was ever given to the petitioners and the other persons on 8th January 2024, and there is no document placed on record to show that the authorities have ever directed either of the two petitioners to open any box, locker, safe, almirah, etc. for the purpose of search and inspection. It is argued that as per Panchnama in the case of petitioner Dilbag Singh at Dilbag Sandhu, it has been mentioned that search had started from 8:25 hours on 4th January 2024 and had concluded on 8th January 2024 at 13 o'clock hours, and the details of the acts done at the time of the said search have been mentioned, and it has been stated that the actual search had started at 8:40 hours on 4th January 2024, and it is only on 4th January 2024 that the officer had searched the premises by checking the documents in the cupboard, almirahs and drawers, etc., and there is no such averment in the said Panchnama with respect to any subsequent search of compounds and almirahs, etc. on any subsequent date after 4th January 2024, and thus, keeping the petitioners in the premises without their consent for the purpose of the search would amount to illegal detention. Reference has also been made to the Panchnama in the case of petitioner Kulvinder Singh, which has also been annexed as Annexure 10 in the said petition, and it has been argued that even in the said case, the search had started on 4th January 2024, and it is only on 4th January 2024 when the lock of the room, the key of which was not available, was broken by calling a locksmith, and the said person was called by Rakesh Kumar, Assistant Director, and the breaking of the lock was done in the presence of one Manoj Kumar, son of Bhim Singh, who had been working as accountant for the last 5 years for Kulvinder Singh. It is submitted that it has been further recorded in the said Panchnama that on the same day, the almirah which was in the said room was also opened by breaking the lock of the same, and thereafter, no such incident has been mentioned on the subsequent dates. In the concluding part of the said Panchnama in the case of petitioner Kulvinder Singh, it has been specifically mentioned that everyone present at the premises was allowed proper rest, food break and washroom break, and from the same, it is apparent that there was complete control of the respondent on the movements of the petitioners and their family members, and it is the respondent authorities who were allowing the petitioners and family members to take rest, food and washroom breaks. Thank you, students. Over.